Hi everyone, Joe Gentili from Saroff Gentili LLP. I hope everybody's having a good day. Today I want to talk about consular denials. So this is a topic that historically has been a pretty depressing topic in immigration law because there's this doctrine out there called consular nonreviewability, which basically says that if a consulate makes a decision, by and large, a federal court can't review it, and you're stuck with it. It's pretty much the end of the line. So the advice that a lot of immigration lawyers give their clients, and probably still give their clients, is that if you have a denial from a consulate, it's more or less final. So fortunately, there was a case that was decided recently, late last year, called Muñoz versus the State Department, which punched a hole in that doctrine of consular non-reviewability. And basically, what that case decided is that if you have a U.S. citizen that's impacted by a consulate's decision, so let's say you have a U.S. citizen wife sponsoring their husband to come to the U.S., if the consulate is going to issue a decision, a denial, they have to give a rationale, and it has to be done on a timely basis. So what the court is saying seems perfectly obvious to me, but is new, is that if a U.S. citizen or an American's constitutional rights are imputed, such as your right to liberty to live with your spouse, then you're entitled to due process. You can't just have an agency say no, and I'm not telling you why. Due process is required. So this may seem obvious and it may not seem like a huge deal, but it is, because what it does is it gives people that have had consular denials hope to have that reversed where it didn't exist before. So my firm has recently handled a couple of cases where we were able to get consular denials reversed, using this decision as a weapon, as a tool. So the decision is not a silver bullet. It doesn't do away with the idea of consular non-reviewability. It's not a magic solution, but it does give you a fighting chance, and it does give you enough breathing room in some cases to challenge a denial if the denial is wrong or egregious. So for people that are dealing with consular denials, it's probably worth it to have an attorney that's familiar with the Muñoz case, that has worked with it before, that has litigation experience, to review your case and see if there is hope to challenge it. Not, since this is pretty recent, not every immigration lawyer is up to speed on this. So even if you've been told that there's really nothing that can be done, maybe there is. So that's what I have for today. I hope this information was useful. And if you have any questions, please feel free to reach out to me at any time to discuss. Thanks. Bye bye.